This is Office Talk with Annette Stepanian. Hey everyone, welcome back to another episode of Office Talk. I'm your host, Annette Stepanian, and in this week's episode, we're talking all about patents. Now, I find that a lot of folks get the term patents confused and jumbled together with copyrights and trademarks. All three of these are forms of intellectual property. So if we think of intellectual property as an umbrella, patents, copyrights, and trademarks will fall under that umbrella. I usually think of these things as assets in your business. So these are different ideas, different methods, different inventions that you've come up with that probably have some sort of value to you and your business. And we want to see if we can protect them using these three different vehicles. Now, as my guest, Karima Gulick, a patent attorney, is going to explain in this episode, patents are a little different than copyrights and trademarks. Patents tend to protect things like inventions, methods, processes, designs, and in contrast, copyrights tend to protect creative content, for example, photos or novels or designs or pictures or sculptures, and trademarks tend to protect things like logos and slogans and brand names, things that are brand identifiers with certain goods and services sold in the marketplace. So if you have an idea, if you have a certain product, if you have a certain method or process that you think is pretty unique and you want to see if it is worth protecting, I want you to listen to this episode. Karima is going to talk all about what patents are, who needs to be considering them, what the patent filing process is, and much more. Let's go to the show. Hi, Karima. Thank you so much for being here today.
Hi, Annette. Thanks so much for having me.
So I wanted to have you on. I'm just going to get straight to the point here. I wanted to have you on because you are a lawyer and you work and specialize in patent law. And I wanted to bring our listeners, give them a background, kind of a 101 course about what patents are, why they need to be thinking about them, if they need to be thinking about them. So that's what we're going to be diving into today. But before we get into all of that, why don't you bring our listeners up to speed about who you are and what you do?
Sure. So as you mentioned, my name is Karima Gulick and I'm a registered patent attorney. Before becoming a patent lawyer, I was an engineer working in the aerospace field for about a decade. And I came up with an idea, pitched it to our innovation council. They really liked it. They invited me on the board. And that board basically was getting disclosures from engineers and inventors. And once we had a great idea or an idea was submitted to us, we would evaluate it, see whether it was worth patenting, adding to the portfolio of the company. And I absolutely loved getting all these disclosures from the inventors, being on the cutting edge of technology and hearing all these amazing ideas before they hit the market. So I loved it so much I decided to go to law school and become a patent attorney.
Wow. After being in the working world, you went to law school.
Yes.
Oh my goodness. That is tough.
It was worth it.
Yeah. Good. I'm glad to hear that. So you go to law school, you pursue patent law.
Yes. So, and then I started working throughout law school. I was clerking with my currently mentor, learning how to write patents, what you can and can't do. And then I started working for a law firm here in Southern California, one of the top filers at the United States Patent and Trademark Office, and got my feet wet, learned as much as I could. And after I felt ready, I decided to go and start my own practice with my mentor, who is now my off counsel. So we still work together on pretty much every patent that we do is together.
That's awesome. That's awesome. So if folks don't know, isn't it funny how sometimes, people assume that just because you're a lawyer, you know everything. And I always joke is because sometimes we act like we know everything, but patent law is a very specialized area of law. Usually you need kind of a more engineering science background, and you do need to go through you need to pass an extra test, right? In order to practice in front of the patent office. So yeah, so Karima's really smart. That's my point here. Did you want to say something?
I was just going to say, in order for someone to represent you with the United States Patent and Trademark Office for patent filing, you need to sit through the patent bar. And that one requires you to have either a STEM background, so science, technology, math, or have taken some extra tests in order for you to sit for that. They want to make sure that whoever is handling your patents has the technical knowledge to guide you through that.
Yeah. So that's a great background for folks to understand. Okay, a lot of folks, obviously they interchange the terms copyright, trademark, patents, it's all falls under this umbrella of intellectual property. And, we have episodes about copyrights and trademarks, but let's dive into patents. What are patents? Just go for it. Why would I need to, or should I even consider getting a patent?
Sure. So there are a few kinds of patents, and then I'll explain in details the different kinds of patents. But essentially, if you have an invention, if you have an idea, you don't really need a prototype, but you need to be able to describe it to someone who's skilled in the arts, as we say, or someone in the field, to where they can basically, based off of your description and your drawings, they can make the invention, or they can follow your process or your manufacturing method, or etc. And the reason you do that is because you want to protect your idea, and you want to make sure that if someone uses your product or your process, you have something to go after them. So what it does essentially is it gives you rights. So think of it as like metes and bounds of like a piece of land. It gives you that piece of land. No one can come and step on your piece of land, and you're allowed to use and make and sell that product. And then only if you decide to let someone use it, then they're allowed to use it. Mm-hmm. It's not forever. For utility patents, and I'll explain in a little bit the difference between utility and design and plant patents. But for the utility one, the one that covers how the thing works, you get 20 years from filing. And then for the design patents, that's less than that. You get 15 years. And then a plant patent is separate. And then the way I like to describe these different kind of patents and like the difference between all that is think of it like a Sharpie. I think everyone knows what a Sharpie pen looks like.
Yeah.
So if you were to, you can get a utility patent on that would be how the pen works. So basically you have a cartridge inside, you have some ink. Once that you have the tip of the pen, once the tip of the pen hits the paper, that's how the ink is on the paper. So you describing how this thing works and how to make it and what to fill the cartridge with and things like that would be the actual utility patent. Now, if you just look at the actual shape of it and the look and feel of it, the Sharpie pens usually have like a distinct shape to them. You could protect the way they look through a design patent. And design patents are used a lot in the fashion world, or I don't know if you remember the big Samsung versus Apple case, the that was actually over a design patent. So basically Apple was trying to protect the way and look of their phone. And so was Samsung. And at some point they were basically saying like, this is basically infringing on my patent. Your phone looks too much like mine. And then Apple was saying, no, yours is looking a lot like
yeah.
So that's where that came from. For plant patents, that's completely different. Basically, if you can come up with a new variety of plants that you can asexually reproduce, then you can get a plant patent on that.
Like a plant, like a physical plant?
Exactly, yeah.
Oh, okay.
So either a fruit or like a new rose or a new plant, you can also get a patent on that. So these are the three different kinds of patents
that
are out there.
So this is mostly for folks who are creating physical products, correct?
Yes, for the design patents, it's an actual physical product. So you're trying to protect the way and the look and the shape. But for utility patents, it doesn't have to be a physical product. Software can be protected through patents, processes, manufacturing, methods of doing things. So if you come up with a new method of, I don't know, making the next way of like making a new milk or making a new cream or things like that, then you can patent that as well.
Okay. So, I mean, I work with a lot of entrepreneurs and small business owners, and it's so daunting, all of this, right? But I get so many people who are like, I have the next best idea,
yeah.
And I want to protect it before, I go out. So at what point, do you advise your clients, okay, this is the time you need to start talking to a patent lawyer or just, an IP lawyer about whether your idea or your process or your invention or whatever, your method, your design is worthy of being, not worthy, but eligible for being patented?
Absolutely. That's a really good question. So another thing that's different about patents that you don't have for trademarks or copyrights is that there's a bar. If I come up with a product or I've come up with a great new process and I go and share it with the public through a seminar or write an article about it, post it online, or basically if I share my product or start selling it, the clock starts ticking. I only have a year from the time I actually disclose or start sharing my idea with the public or start selling it to the time I can actually get a patent.
Mm-hmm.
And then after that year, you really have to come up with drastic improvements on what you've done, something that is non-obvious, like we say. But basically, it has to be like a major improvement on what you've done in order for you to get a patent on that. So that's the other thing. Like there's the whole, before you start disclosing it to others, you want to get some sort of protection.
Mm-hmm.
And that's where there are a couple of different, so for utility patents, I know this is a little too much, but I'll try to explain it to break it down as best as I can. So for a utility patent, so for example, I'm trying to protect my next new app, or I came up with a great way of like mixing, I don't know, for doing a new way of coming out of doing sculptures, or I came up with a great something new of doing something. I'm trying to think what it would be like in the creative world.
What would be, so for instance, I have a new method for creating, I don't know, designing invitations. Is that, or like letterpress?
Sure.
Can you have a new method for, I don't know. But,
yes.
Okay.
We can definitely do that. Okay, so you came up with the greatest new method of doing invitations, this beautiful letterpress, only you can get it to work this way. It wasn't done before. You have to put the paper at a certain temperature, and the metal, the way it hits on the paper, all these things that you're doing differently, you can protect that. So before you start hitting the market with that, there's a couple of ways you can protect your idea. There are two different kind of patent. There's the patent application, and that's the non-provisional. That's basically the one that matures up to become a patent. There's another type of application called a provisional application. What it does is it gives you a date, like a priority date. So for example, you came up with all this great idea, and you're going to a seminar next week, and you want to make sure that you're getting protected, because what if people are really interested and you want to start licensing it to others, or you just want to start keeping all the profits for that, or you even want to assign your rights or sell your patent to someone else. I would strongly advise, especially if you're in a little bit of crunch for time there, to go and file a provisional patent. And this is only for utility. So for the way
something is used, right? Exactly. Utility, yes. The way something is used versus the way something is designed. Yeah.
Exactly.
Okay.
Yeah, absolutely. And what the application does is it puts a priority date for you at the USPTO. It holds your place in line. No examiner is going to look at that application, and the application by itself will never mature into a full patent unless you file a non-provisional application and then claim the priority date for the provisional. But essentially what it does is, if someone else comes up with the idea and then they file it after they've heard, for example, what you came up with, and then they start like adding a little improvements and then file it as their own idea, you basically have an older priority date than they do. And one, it's cheaper. The application is a lot cheaper, and it doesn't have that many formalities that the actual non-provisional patent does. So essentially, you can basically have your panel presentation, add a lot of drawings to that, describe it to the best of your abilities, and file that yourself if you don't have the means to actually talk to an attorney for that. It's always best to talk to an attorney about it, because you want to make sure that everything that you're trying to protect is indeed protected before you start sharing with others. And then the other thing is that in 2013, we moved from first to invent to first to file. So essentially, if we almost came up with the same idea around the same time, it's a race to the patent office. So whoever files it first basically has priority on that.
Wow. That must keep patent lawyers really busy.
Yes. It was a great change, and it was basically something to put us in the same system as the rest of the world, because before it was a little more complicated.
Okay, so what can somebody expect? So let's say you're like, I have this great idea about making new letterpress invitations and mixing my colors and whatever you just said, warming the plate up or whatever. And so I'm like, okay, I know there's something here. So they come to someone like you, they, work with a patent lawyer. What can they expect? Like, what are some things that they should have prepared, or certain questions they should ask of a patent lawyer? Because I find that a lot of folks, they have that good gut instinct of like, okay, I feel like I need to go to a lawyer. This sounds like something that, I need to speak to a professional about. But what happens is they don't know where to start. They don't know who to talk to, or when they're there, they don't know what kind of questions to ask. So can you give us a little bit of background about, how would you advise somebody that if you are going to be pursuing a patent and working with a lawyer who, first of all, should be a patent lawyer, what are some things that they could do to prepare for that conversation?
Absolutely. And that's a really good question. So the first step I always advise my clients or anyone who's about to embark on the process, it's getting a patent is a business decision before and after all. It's a long process. It's an expensive process. Is it worth your time and money and effort pursuing this? So that's the first question. And that's a question that only you can answer.
Can you, and sorry to interrupt you here, but can you kind of give it, like, what are we looking at in terms of an investment? You know, I know it's probably hard to answer, but like approximately ballpark. What can someone expect to have to pay for the patent filing process and working with a lawyer? Like, what should they allocate in their minds and in their budgets?
Yeah. So a design patent is going to be cheaper than a utility patent. Essentially, all you need is really good drawings to protect your invention, your design, your way and look and feel. So for design patents, you're looking anywhere between $2,000 to $5,000 or $6,000. I've seen attorneys charge around that for design patents. And then the design patent is usually a lower threshold, so it's easier for you to get a design patent. The patent office looks at it, they do a little search, see whether there's an identical design, and if there isn't, then basically you're issued a patent for that. For the utility, it's a little different, and then you're looking at anywhere between $4,000 to $15,000 or maybe more, depending on the complexity of your idea and how long it takes to get the patent. There's an optional first step of doing a search. And I highly recommend to anyone looking to get a patent on their idea to do a search. Go to patents.google.com. The Google patent engine is amazing. It really is. It was a game changer in the field. And it's available to anyone. It's free. I would strongly suggest sit down and think about how you would describe your invention in a few sentences. So you're coming to me or you're coming to a patent attorney to describe your invention. Sit down and write down 2 or 3 sentences that you think would describe this like to a high level. And then highlight or underline the keywords that you think make a difference. Go and enter those into the Google patent search and see what comes up, just to get a feel for what's out there, what has already been done, what you could improve on, what kind of rejections you would get from the patent office. When I said that it was a long process, it's a really long process. You're looking at a couple of years for the utility patent. Same thing for the design one, maybe a little less. There are ways of expediting it, and you can pretty much get something in 6 months or around that time frame, but it costs more money. You need to do more research and you need to pay extra fees in order for you to expedite the process.
And that 20-year timeline on utility patent starts running from the date you file, right?
Exactly.
So yes. It could take 4 years for it to get approved, but starts counting down your 20-year timeline. Okay.
Yeah. And then, so here is basically the process. So after you file, you have to wait for a little bit. Currently, for a utility patent, on average, you're looking at about 16 to 18 months before your first response if you don't pay for the expedite.
Oh my goodness. Yeah, I thought 3 months for trademarks was a long time.
Yeah, no. Okay. Like really, you wait forever.
Like you could have probably a whole child during that time.
Exactly. Like your life has changed.
You could give birth. Okay. So 16 to 18 months before.
Married, divorced.
16 to 18 months before an examiner even picks up your file, it sounds like, unless you pay extra. Okay.
There's just like a backlog. There's 500,000 current application at the USPTO.
Oh my goodness.
For patents. So it takes a while. You can pay higher, around 700, maybe a few thousands if you want different strategies to expedite this and get a response faster. But that's how long you're looking at. And then, so back in the day, it used to be 17 years from the day you actually get the patent. But in 1997, they changed to the 20 years from the date of filing. So I just wanted to go over the process a little bit.
Yeah, please do.
Application. And then after you file your application, like I said, on average for utility right now, 16 to 18 months to get an office action. For utility, you're almost guaranteed you're going to get a rejection. And one of the most common rejections is they'll take different patents from various fields or maybe the same field and say, look, if I combine this and this and this, I could come up with your idea. How is your idea different? What's stopping me from combining this and coming up with that? And that's where it gets a little tricky. So basically, you have to prove that it would not have been obvious to someone in the field to combine. And even if they combined it the same way, then you wouldn't come up with these results. And this is how we're doing things differently. Usually, you have the first office action. and then you respond to that. You have 3 months to respond to that, or 6 months if you want to pay extra money. It's all about paying extra money.
Seriously, right? Are you guys noticing the theme here?
Anything. Nothing is free. You want to copy?
We gotta pay the salaries of those examiners at the patent office.
Got to pay to play.
Yeah.
So that's the first office action. You respond back. Most attorneys will have an interview with the examiner, which is great because instead of just wasting a response like that and not knowing whether it's going to work or not, you could pick up the phone, talk to them, see whether it's something that, whether your argument will overcome it or not. And then after the first one, they typically come up with a second different rejection or sometimes the same rejection. And then you respond to that. And then at that point, you either get your patent issued. And if you do, congratulations. You still have to pay maintenance fees. You don't have to pay maintenance fees on these 9 patents, but you still have to pay maintenance fees on the utility one. And then if you, after the second office action or the final office action, if you still didn't get the patent, you can either request a continued examination. So essentially you keep paying the USPTO forever and they keep doing searches and you respond, or you can appeal it to an appeal board at the patent office.
So what happens if, and maybe we're getting too like nerdy with this, but what happens if like you're, in this process, you filed, you've waited your 18 months, you've got an office action number 1, number 2, and you have this letterpress idea, right? And in the meantime, you start seeing people utilizing your idea. They're starting to copy you. Do you have any rights yet as someone who is allegedly the original inventor of this idea, but yet has not received a patent from the U.S. Patent Office?
Yeah, that's another really good question. So before you have that patent in your hand, you technically don't have anything. All you have is an application. So you could put them on notice and tell them, you know what, as soon as I get this, then I'm coming after you. And you can basically charge for everything that they've been selling under your idea during that time. Exactly.
Yeah.
Or lost profits. But until you have those rights, it's hard for people to take you seriously.
Yeah. Yeah.
Oh,
I'm all stressed out. No, because no, you did a great job. I guess I'm just stressed because I know I see so many people come to me and, they're so excited. They have this idea. I mean, the first thing is your idea, it has to be unique, right? It has to be novel to a certain extent. And I think people sometimes think they have novel and unique ideas, but they're really not. So it's really important, somebody has come up with it before. So I think it's important, like you said, is to take that time initially to do your research, to do the search, whether it's, do they pay a lawyer to do that search other than, that kind of initial search that you recommended on Google? I would imagine that there are, lawyers they can hire or search companies they can hire to do that initial search for them to see if this has any merit.
Yeah, absolutely. It's an optional first step to do. I mean, these searches, depending on how deep you want to get into the search, but I think it's always a great idea because this is such a long and expensive process. I think it's worth it to just do a scan, see what's out there, do a thorough search through a search company if you can. The problem with that is once you file for a patent, it takes 18 months to publish. So essentially, you're not going to be able to see everything. So basically, if I filed today, my application won't, or if I filed a few months ago, my application won't publish with the USPTO until basically it's been a year and sitting at the USPTO for a year and a half.
Yeah.
So there's that whole blind period where you're not sure exactly what's going on.
Yeah, other applications like yours, right, that you don't have access to or won't come up in a search result.
Absolutely, yeah. And so for patent searches for the utility or even a design one, you're looking at somewhere between $500 to $1,500 or $2,000. And sometimes what's good about doing the search is that it prepares you for like the possible rejections that you're going to get and strategize based off of that on what you can and can't do.
Yeah. So, okay, if you're talking to somebody, they've come into your office, what are some kind of best tips, that you'd give them? Like make sure you do these, 2-3 things to set yourself up for success. Obviously, there are no guarantees, but you touched upon some of them, but kind of any kind of mistakes or lessons learned that you would recommend people take into consideration.
Yeah. So like I said, the first thing is it's just doing the search and do a thorough search on your own. Like I mentioned, the Google patent engine is truly amazing. So start there. And then the second thing is, if you know you're going to be sharing this, or you know you're going to be selling it in public, and you want to give yourself like some time to test the market with the product, file for a provisional. The requirements are a lot less strenuous than the non-provisional. So, and it offers you some sort of like peace of mind for that 1 year before you file for the non-provisional patent, for the actual patent. So if you have to, just sit down on your own and write down everything that you know or can think of about your idea and invention, and then attach some drawings to that and file it. If you can hire an attorney for that, great. If you're on a budget, I would say still file something, it's better than nothing, and give yourself that 1 year to do some market research, see whether this is something that's worth pursuing, see whether there's a market for it, see whether someone might be interested in licensing your idea, or even buying the patent from you or your idea from you. But truly, especially for patent, if you don't protect it, you can't really enforce it.
Mm-hmm. Yeah. So that, I guess maybe this is obvious. So what is the benefit of the patent? So let's say I've gone through my 18 months, I've done my 2 office actions. I finally have that patent. Like, so what's the big deal? Again, if you watch Shark Tank, maybe you already know the answer, because they're always obsessed about, do you have a patent? Is it provisional? Is it, so I always see like Lori asking that, but like, what are some of the benefits of it?
Sure. So, Annette, we're back to the letterpress that you came up with, that beautiful letterpress. And then you start making these cards, and only you can make those cards. Someone tries to copy what you're doing, you can stop them with just that one letter saying, this is my patent, you are infringing, your machine is like, your letterpress is close to mine. If you don't stop making them, or we can maybe talk about a licensing deal if that's what you want to do, and they can start paying you for that. It gives you a monopoly on the market. You know that with whatever you have, the little metes and bounds of your claims and what your patent, the little metes and bounds that your patent gives you, only you can stand there, and only you can start selling and manufacturing and making those products. So having that peace of mind, knowing that you don't have anyone competing against you, or they can't, basically, if it's exactly like what you do.
Okay. Yeah. So that's, for 20 years or so, or 16 to 20 years, you have like basically first rights. And it's just like trademarks or copyrights. Like there's a lot of value in being the holder to that intellectual property and commercial value, whether it's you get to hold it yourself, or you get to license out your designs or your inventions or your methods or whatever. Kind of going back to the designs, because I do work with a lot of designers, and I could hear them saying, well, I have this unique design for a greeting card, for instance, right? Or I have, you said about a lot of fashion designers will file for design patents for their designs. What is kind of that litmus test? Because for folks, because I would think that a lot of those things would be protected under copyrights, the actual sketches and things like that. Where and should patents, at what point do patents get involved when you're talking to someone who's a designer, whether it's, a graphic designer or a fashion designer? Should they be considering a design patent?
Honestly, if it's a big money maker, if it's like a good product to you, it's your bread and butter, and it's your actual like design. And the other thing with design patents is that it's going to protect your design the way it is. If someone changes things to it to where you don't recognize the product anymore, or even if it's, confusingly similar, then they can't make those products. If it's a design that's important to you, if it's, you're making a lot of money on that design, then it might be worth the investment. It's probably worth the investment. And like I said, the design patents are, one, a lot cheaper, and the threshold to getting those is a lot lower, because, and then you can pay a little extra. It's a few $100s for, depending on your entity status, to expedite the process. And the last ones I've been doing for design patents, I've been getting the first response within 2 to 3 months. And that's like $200 or $400 extra to get that. The reason they came up with that was because in the fashion industry, things move so fast that they want to protect their designs, but they want to make sure that they're getting their patents right away to stop others from counterfeiting and making that.
So what are they? Literally, like if Kate Spade has a new bag design, they submit that bag as for a design patent?
Exactly, yeah. And then the last big case was Under Armour and Lululemon for their athletic gear, for their tops with the built-in bra. And Lululemon has like a kind of distinct design where the straps in the back are, crisscrossing. And then Under Armour came up with something similar. But yeah, that's absolutely worth protecting. That's the cool design that you don't see everywhere else, and you came up with that, and you're making it work. So it definitely, it's worth it.
So like there's that case with the Christian Louboutin with the red soles. Mm-hmm. I mean, they filed like there was a trade dress, right? So they protected it probably with, I mean, we don't know for a fact unless maybe you do, but they could have also filed for a design patent to protect that as well.
Yes. Okay. And then you can do that. But most design patents are in black and white. Like you don't claim color unless you really want to. So for example, for the Louboutin, yes, it would definitely be worth claiming the color in those. But for the most part, you're trying to go for the broadest protection that you can get.
Yeah.
So
interesting.
And then design patents are a lot easier to get than trade dress, because trade dress, you have to basically, consumers need to start associating your designs with your mark. Whereas for design patents, it's you file it. If no one has the exact same design, then you're good. You basically have a patent.
Yeah, and you don't even have to use it. Like with trademarks, you still have to, one of the requirements is it has to be in use in commerce, and you have to continue using it in commerce, or else you kind of forfeit that. Right.
Yeah.
So, oh my God, I could totally nerd out, especially with the fashion.
I know. It's really fascinating with the fashion.
Yeah, because I know they've been trying to protect their designs against counterfeiters, and I know IP laws don't necessarily, they're not as all-encompassing as I think the fashion industry would like to see. But, that's why I always tell people, like, that's why you see people's, like, the logos, the company logos on everything, right? Like, you see it on the pattern, you see it on the T-shirts. It's because it's a way of protecting their designs, is because at least they have the trademark over that logo. So... oh my gosh, I could totally nerd out. Is there anything else, I really appreciate you taking the time to do this, because I know it's such a convoluted and difficult topic. And then to be able to, explain it so that the rest of us can understand it is not an easy feat. Is there anything that you'd like to add, or any other kind of last minute just thoughts on this topic that you could share with our listeners?
Yeah, like I said, I'm going to reiterate it again because it's really important to just do the search and see whether it's worth pursuing. A lot of patent attorneys will have either free consultation or have that for rather cheap. But I know a lot of them who do the free first consultation. So it's worth just picking up the phone, talking to someone, and seeing whether your idea is patentable. And then once you decide it's patentable, there's still the whole, is it worth it? The business question.
Yeah.
So that's something worth taking the time to sit down and think about that.
And I think given the cost and given the potential upside, given the length of time it takes to go through this process and the complexity, I really do think it's important to have the right people on your team, like a patent lawyer, who can expedite this not expedite, but make sure that it is done in such a way and presented in such a way where it's going to increase your chances of having it approved, or approved with minimal, office actions coming back. And so I think there's a huge benefit, especially, when it comes to patents. There's a lot that, you could probably do on your own when it comes to like the law. A lot of my listeners are pretty savvy. They can kind of figure out a lot of the stuff on their own. But this is one that I know if I was in the situation, I wouldn't even attempt it myself. I would go to a patent lawyer.
No, don't. Seriously. I was encouraged in the provisional. That's if you really don't have any money and because no one looks at the provisional, it just gets you a date. But for the non-provisional, do not attempt to do that by yourself. Because you're blocking, you essentially would be blocking yourself from getting a real patent. And drafting those claims is really the hardest part.
Yeah.
And the Sarah Blakely from Spanx, she was really savvy, she didn't really know how to get a patent, did a lot of research, and she said she got to the claims part and she definitely needed to get a patent attorney because there was no way she was going to write those claims by herself, even though she had done a lot of work on her own and tried to come up with in writing as much as she could.
Yeah.
Yeah.
Do not pass go without calling a patent lawyer.
Exactly. Just one more thing that I wanted to add I mentioned the utility is 20 years, but there are strategies that can help you extend the life of your patent. You can file for continuations or continuations in part. And that's something that your patent attorney can definitely help you with.
Yeah, absolutely. I mean, there's so many nuances, and that's the hard thing about sometimes when you want to kind of educate people at this level is we're speaking at it very generally. And so that's why it's always great to talk to a lawyer who actually knows what, your particular idea and can advise you, because there's so many little nuances that can, determine the strategy one way or the other. So Karima, thank you so much for being here. And if there's, if folks want to get in touch with you, if they want to have that conversation with you, where can they contact you?
Sure. Probably the best way would be thepatentlady.com. That's
what is
my
Patent
site.
Lady?
The Patent Lady.
Oh, cute.
Yeah. .com. That'll take you to my site. My email address is Karima, that's Karima at kgulick.com, KGULICK.com. I'm also on Twitter and Instagram. My handle for both is Karima Gulick, that's Karima, and last name is Gulick.
Perfect. And we'll definitely link all of that stuff up in the show notes, as well as all of the resources you mentioned here today. So, Karima, thank you so much. Nothing like talking about patents bright and early in the morning to get the day started right.
Exactly. You don't need coffee.
Thanks again for being here.
Thank you for having me.
Well, there you have it, my friend, your 101 course to patents. So next time you are watching Shark Tank and Mr. Wonderful asks if the contestant has a patent, you will know exactly what he's talking about. So if you want to learn more about Karima, or you want to get some of the resources that she mentioned, make sure to head on over to the show notes at AnnetteStepanian.com/podcast/71. I'm going to wrap up another episode, and I'll see you back here next week. Before you skip to that next episode, I want to invite you to a special event called Legal 360 Live. In this live online summit, we're going to walk through what you need to know, legally speaking, as you start and grow your business. So if you're ready to roll up your polka-dotted sleeves and finally get your legal house in order once and for all, head on over to yourlegalbff.com/live. That's yourlegalbff.com/live.